State Police Barracks, is that correct?
That is correct.
And that is a service business rather than commercial, isn't it?
Yes, I would say it's service business.
And to the south is open field,
There are open fields to the south. Yeah.
and to the east is woodland.
That is correct.
North of the police barracks is a landscaping company, correct?
Commercial landscaping company. Correct.
And there is also in the area just to the south and to the west a farm stand, is that right? A lesser farm?
Farming stand, yeah.
A commercial farm stand?
I believe they sell things to people, so I would classify that as commercial use.
As opposed to an agricultural use?
Well, it's a gray area these days, but certainly, I would say if it's selling to retail, as a retail establishment, it would qualify as a commercial use.
And you also state that the project fence will be set back 495 feet from Route 7. Can you tell me how far the panels are set, the solar array is set back from the parcel boundary?
Not without measuring it. I have that measurement in my folder. It's at 495 feet back from Route 7. Which parcel boundary are you referring to? That'd be helpful.
The parcel on which it is located.
Okay.
Well,
So
I object. The cross question was about the witness's testimony about how far is the fence from Route 7. That's what the witness testified to.
He testified to how
He
far
did
is it
not
from Route 7?
testify about the parcels.
Correct, and I am asking him, how far is it from the parcel boundary? Trying to
Okay.
establish the location of the project.
Okay, so if you look again at Figure 2 on my pre-trial testimony, report my pre-trial testimony, revised March or April 22nd, you will see that the proposed project fence is fairly coincident with the western property line of the parcel on which it's located. And that fence is set, the fence line is the array is set back approximately 20 feet from that point.
And your visual assessment report at page 21 says that these plantings, this screening mitigation planting, will be 6 to 8 feet off the fence line. Is that correct?
Could you direct me to where that's stated?
I would like to. My note says page 21 of your visual assessment report.
It's in the bottom paragraph.
Correct, 6 to 8 feet.
And when you say off the fence line, again, that means west of the fence line, correct?
Yeah, it says parens west of.
Yes, and so again, that shows them on that, that front parcel, the parcel that has highway frontage, is that correct?
That is correct.
And can you tell me what the setback is, what the side setback is on that southerly boundary to the fence line from the boundary that says maintaining existing native tissue?
I don't have the exact measurement, but based upon the site plan, I would suggest it's probably on the order of 50 feet or so. Plus or minus.
In terms of efficiency and time, these questions about where the project is sited and the measurements, all the measurements are shown on exhibit SSE GB-2 on the site plan.
Mr. Kane, are you aware of what the town's setbacks are for this zone?
Objection, Your Honor, not relevant. The board ruled in its September 2015 order that the town zoning regulations are not relevant in this proceeding.
However, I'd still like to hear what the setbacks are. My understanding is that the town's comments, which the board is supposed to consider, reference those setbacks and would like the project to comply or to consider them at least. So
But that's fine, but he's asking the petitioner's witness what the town setbacks are, and he's not a town.
Well, let's see if he knows. Let's see if he knows.
I was just asking if he knew.
I do not know.
Okay, there we go.
Do you know what the Act 56 statutory setbacks for 500 kW solar development are?
Yes.
I object, Your Honor, that law does not apply to projects that were filed well in advance. And that is something that the board has already determined.
Without ruling on what the board has or has not determined, those setbacks are in statute. The board is aware of them, and so I'm not sure how useful getting that information from Mr. Kane is going to be right now. So.
And so just to confirm that what's referenced as the existing native hedgerow or the hedgerow on the southerly side of the parcel, the project does not have legal control over that area, does it?
I don't know what the legal status of the property is relative to that area.
One more question, Mr. Kane, regarding the, you did, in your supplemental analysis, you did a supplemental testimony. Figure A to your exhibit SSE MK3, the single facility analysis report. You indicate the location of 3 additional solar developments that are on the western side of Route 7, is that correct?
Yes, that's correct.
And those are in fact visible from what you had noted in your original testimony as visibility point B, is that correct?
Potential. One of the projects that's indicated on that list is NM 4272, which is probably not visible from given the distance and the setback from the Route 7 corridor.
But the 2 solar arrays indicated as MM 4296 and NM 5831 are in fact visible from what is referenced as photographic point B on your viewshed plan figure 1, is that correct?
From the location approximately would be, yes, that's correct.
I'm sorry, for the location?
Approximately would be placed on that plan, yes.
I have no further questions for Mr. King.
Any follow-up from the department? I have no questions.
I have a redirect. Mr. Kane, do you recall the town's question on your pre-file testimony regarding whether a cell phone tower was commercial?
Yes, I do.
And do you recall your answer that it was service rather than commercial?
That's right.
Can you explain what you mean by that?
Yeah, I mean, service-oriented business would be obviously something that provides a good, that this public function has some value to the public, and the cell tower would be something that would be an enterprise that would provide some public benefit.
When you were just asked whether, by the town, whether another net metering project is potentially visible from this particular project, do you think that that is the correct inquiry?
Objection.
I can rephrase. Do you think it's relevant whether one can see a net metering project from another net metering project?
In the context of aesthetics?
In the context of the single facility issue?
I think that, yeah, again, I think the complexity there is not just one of can you see it, but is the context within which you can see it. And as I noted in my supplemental filing, My analysis of the projects that Ms. Hill referenced were that even though they may be visible from from the same corridor, they aren't perceived necessarily, visually perceived at the same time, which I think is part of the conversation around whether or not something is considered a singular facility. And that was exactly the same reason why in my original analysis we evaluated the proposed 350 kilowatt project along with the 150 kilowatt project, because they were perceived, or would be perceived, essentially as a singular facility.
Thank you, I have no other questions.
I'd just like to clarify, if I may, Mr. Kane, you referred to this as a cell tower, didn't you?
The cell tower on the property?
Yes. Are
Yeah.
you actually aware of it as a cell tower or a microwave tower?
I may have used a colloquialism to define it as a tower, but I'm not sure exactly its function in terms of its, I know it's probably related somewhat to the police barracks and the associated use of communications.
Thank you.
All right, thank you, Mr. Kane.
Thank you.
Thank you.
We have MK1 and MK2 and MK3. Yes. Yes.
I didn't steal anything, did I?
No. I thought you were talking the other way.
Also, one other thing that normally when witness or exhibits and testimony are offered, copies are provided to the bench. I know that this is a little bit of an odd case, but to the extent you have copies, it'd be helpful. I have the original copies that were filed right here, and I've been able to follow along pretty well, but sometimes it goes a little quick. So.
Well, I'm giving my copies to the court reporter, but I could give them to you.
Yeah, we got normally they're like sort of bench copies that are we doodle on and have, but we don't have it. It isn't impeding my function right now. So, but I'll speak up.
I have many copies here of many things, so
Okay.
I'm happy to do that. But I'm giving the original
To the court reporter, right?
Yes.
Yeah.
So let me just get. Did you want to swear him in?
Yes. Please state your name.
Andrew Thomas.
Mr. Thomas, do you swear or affirm that the testimony you're about to give is true and accurate to the best of your knowledge?
Yes, I do.
Good morning. I'm going to hand you the pre-file testimony of Greg Beldock, submitted March 26, 2015. Are you adopting this testimony as your own?
Yes, I am.
And is that a true and accurate copy?
Yes, it is.
Are you familiar with Mr. Beldock's testimony?
Yes, I am.
Okay. I'd like to move the admission of Greg Beldock's testimony as adopted by Andrew Thomas into the record as if orally given.
Objection. Submitted.
I think what I'm going to do is I'm going to hand you,
Okay.
and hopefully at the end of the day I'll have a copy for myself.
Okay.
So, I'm going to hand the hearing officer a copy. But if that could stay with the court reporter, then I
Yeah,
won't
no, we
get in
have
trouble.
I won't know.
I'm going to hand you a pile of exhibits that are exhibits SS and GB 1 through 7, which is a resume, which is exhibit 1. Exhibit 2 is a site plan, general area overview, elevation drawings. Exhibit 3 is component specifications. Exhibit 4 is fence illustrations. Exhibit 5 is town and regional plan excerpts. Exhibit 6 is 45-day package, and Exhibit 7 is historic site letter, which you have previously reviewed, but take a moment to flip through them. Are those true and accurate copies of the exhibits?
Yes, they are.
I'd like to move the admission of the exhibits SSE GB-1 through 7 into the record.
Any objection? Admitted.
These are for you.
Thank you very much.
And I will give the court reporter the marked versions. Going to hand Mr. Thomas his pre-filed testimony dated September 30th, 2015. Did you prepare this testimony or was it prepared under your direction?
Yes, it was.
Is it a true and accurate copy?
Yes.
I'd like to move the admission of the pre-filed testimony of Andrew Thomas as if orally given.
Admitted.
I don't think
I can fish my copy out of here.
I'd also like to hand you your exhibits, Exhibit SSE AT1, which is your resume, SSE AT2, which is a survey, and SSE AT3, which is an Act 250 permit application. Take a moment to look at them. Are those true and accurate copies?
Yes, they are.
I'd like to move the admission of Andy Thomas's exhibits 1 through 3.
Objection. The exhibits are admitted.
And I have a copy for the hearing officer and Mr. Thomas's 3 exhibits. The witness is available for cross-examination.
Thank you. Good morning, Mr. Thomas.
Morning.
Mr. Thomas, you were actually the representative of Senior Solar Energy in the development of the 150 kW solar array for the Lodge of Otter Creek that is already on the site, is that correct?
I was a member of that development team, yes.
And, in fact, Greg Beldock is a principal in Senior Solar Energy, is that correct?
Yes, he is.
And also in the Bull Rock Corporation?
Yes, he is.
And also in the Lodge at Otter Creek?
He is no longer a principal there. At that time, he was, yes.
The existing 150 kW array on the parcel here has recently transferred ownership, hasn't it?
Yes, it has.
And was the CPG transferred?
Yes, I believe it was.
And that was to another LLC, another of Greg Beldock's LLCs, is that correct?
I believe that was to reflect the financial ownership in the project after all of the permits and necessary approvals were obtained to construct, yes.
At A6 of Greg Beldock's testimony, Mr. Beldock testified that the project is proposed on 4.5 acres of a 25-acre parcel for me. Can you please describe for me what that 25-acre parcel is?
I think that's a mistake.
One second. Counsel, didn't, Ms. Walshik, didn't the petitioner provide corrections to this testimony
Yes.
already? Okay. So I just,
The petitioner submitted in Mr. Thomas's supplemental pre-filed testimony a survey that the town had submitted in one of its comments, and so we agree with the town's assertion of the acreage.
okay.
And in your submission of that survey, Mr. Thomas, you advised that that survey had been filed after you filed the application for this project, is that correct?
Can you just, where are you referring to so we get on the same page? testimony September 30th you're referring to?
Yes.
Page 2, line 22.
That's good. Did you testify that in fact the survey was filed after?
I did, yes, that's what it says.
In fact, the parcel had been subdivided back in 2001, isn't that correct?
I think the question at that time was, it was a 10.67 acre parcel, and there was a 2 acre subdivision that was done by the landowner. My answer with question A6 was in reference to the 2 acre subdivision. And that's what I was referring to as when the record was filed in the New Haven land records. And that was for the 2 acre subdivision that had a plat filed on March 10th, 2015.
Okay. You referring to it as a subdivision. Was it in fact a boundary adjustment?
Yes, I believe so. I think it was 2 acres being transferred and no actual construction or anything else.
So in fact, are you familiar with the Act 250 permit for this parcel?
I'm familiar with the Act 250 permit, but I'm not familiar from a landowner's perspective or land development standpoint. I don't know exactly why they've done what they've done over the years, but I am vaguely familiar with that.
Are you the project manager on this project?
Yes, but I'm not the landowner.
And the landowner is not the applicant here, is it?
No.
Who's the landowner?
Peter Norris.
So, referencing Exhibit SSE GB2, the site plan. Can you tell me, which, what area on here is under the legal control of the project?
Could you tell me what area?
What area on here is under the legal control of the project?
Okay, what area, not what area? All of the boundaries are shown on the site plan within the fenced-in area. We also have legal control of the southern hedgerow and the ability to interconnect to the pad mount transformer to the west, along with the landscape mitigation plantings to the west.
So the landscape mitigation to the west is located on the parcel that has the road frontage, correct?
That's correct.
It's on a different parcel than the solar arrays, is that correct?
That is correct.
And the pad mount transformer is also on that front parcel to the west of the solar arrays, is that correct?
That is correct.
And are you the person in your role at, for the 150 kW solar array for the lodge at Otter Creek who had decided to put the 500 kVA pad mounted transformer in that site?
Yes, sir.
And why was that?
I think I answered this question. And just a minute to I think that's a little bit.
I think you're referring to Discovery.
So my discovery response dated December 9th, page 2. I can read from that to expand, or I think that pretty well documents the intent of why a 500 kW.
If you could please read it, it's not on the record right now.
Okay. So should I read the whole thing, or am I excerpt comments of what's applicable to answer the question?
I'd like you to be responsive to our questions.
Okay. So for the 150 kW project on that meter, project 5020I, being myself, Andrew Thomas, On behalf of Borough Corporation, coordinated, instructed, and paid GMP to install.
I'm sorry, you have to go slower. Coordinated.
Sorry.
Coordinated, instructed, and paid GMP to install a 500 kVA pad mount transformer. This was done with the intent that if the solar development project associated with NM 5020 was successful, then a 350 kW AC expansion project would be pursued. The petitioner chose to install infrastructure that would support future development. Potential at its own risk and financial expense. If there was no subsequent expansion project pursued or no CPG issued for the expansion project, the petitioner would bear that financial loss. Planning for the future and development and potential development opportunities is standard practice, especially concerning utility infrastructure installations. Additionally, there is a permitted Act 250 development referencing Exhibit SSE AT-3, commercial lot abutting the project on the west. The underground conduits and cabling with the transformer and its pad would conceivably support a future building at that location if it were built. The installation of this infrastructure is evidence of planning for not only the immediate needs, but also for the future possible uses in the surrounding lots. This thought process needs to be encouraged.
You referenced, when I asked you about legal control, you referenced the access to that transformer and the lines, underground lines of the project. Where are those located?
What located the
Where is the area of your legal control for access to the transformer and the underground lines?
We look at the site plan exhibit SSE GB-2. Everybody sees the transformer location, and from there, there's a straight line noted E at the midpoint of that line symbol, line type. That is the rough location of the underground infrastructure between the existing 150 kW AC system that's there today. It would also be the same location that would be used for new underground infrastructure that would support a 350 kW project if it's approved.
And are there any other rights-of-way or easements on that parcel that the transformer is located on?
Objection.
I'm
He's
not
the
aware of all
Wait,
the-
hold on, let me just put my objection on record. He's not the underlying landowner, he's already said that, and he asked legal property questions about portions of a property he doesn't have anything to do with. I'm happy to have him
rephrase.
answer it, but he's not a landowner.
I'll rephrase, I'm asking if the project has any other easements or holds any other easements or right-of-way other than the transformers, and you said the that easement of the line you just pointed out, marked E, and the area of the proposed mitigation hedge.
There is an easement for access to access the project site.
And where is that located?
It's not shown on the site plan. It's gonna be on the northern boundary of that lot, between the small curb cut that is shown on the site plan. The intent of that access is for temporary construction and future ability to support the 350 kW project.
So construction will access the site through that westerly parcel that has road frontage, is that correct? The same parcel that the pad mount transformer is on?
It's intended that the project, both in construction and in operations and maintenance, would access it via that location while that parcel is undeveloped. It will also access it to the north of the project site where there's a short access gate off a gravel existing, the existing gravel drive. Those 2 points are access points that the site controls.
Mr. Beldop's testimony at question 8 states that the project construction will be staged in an existing impervious parking lot on the, quote, main campus of the property. Where is that located?
Just one. What page and line was that on? Sorry, I'm having a hard time finding that.
That was question 8.
I think, are you looking at question 8, lines 15 to 16 on page 5?
Yep.
Okay.
That's right.
I'm not aware what that.
We corrected the record after Mr. Beldop filed his testimony. Can I just direct you to that? You may have, there was a question from the Department of Public Service about the laydown area, and we clarified that. Just give me a minute, I can direct the parties to that letter.
I can simply ask the witness where the laydown area is.
Sorry, I just wanted to, the filing on April 22nd, 2015, A&R requested the applicant to identify the construction laydown area. And it says the applicant will use the existing gravel drive shown on the existing site plan to store materials during construction.
That letter hasn't been moved in yet, so let's ask the witness to tell us his knowledge of where
Okay.
the laydown area is going to be.
Sure. I should probably move all of our letters in because the way the net metering process unfolded, it doesn't come through testimony all the time. Something that we can talk about later.
Let's take a break and then we'll think about if there's anything else that needs to.
Okay.
So, Mr. Thomas, getting back to you.
Sorry.
We haven't forgotten about you. Where's the laydown going to be for the construction?
The laydown area is not shown on the site plan. There is an existing gravel drive shown on the site plan. On the north side of the project, it's my understanding that we would use that existing gravel drive, and the area is directly to the south of that existing gravel drive as a construction storage area for equipment.
The area's directly to the south of that gravel drive, is that what you said?
Yep, that's what I said.
Okay. And is that within the area delineated as wetlands?
No, it's not.
So, Mr. Thomas, turning to your testimony. In your answer of A7, beginning at line 15, you've testified that the town's planning scheme for this area is not economically viable. Can you describe for me the uses of the adjoining parcels?
The current uses of the adjoining parcels are a state police barracks, a commercial nursery landscaping operation, a open agricultural hayfield, a commercial farm stand. Those are the, and there's an existing
your testimony, at, that same answer, page 4, lines 8 through roughly 10, 12, presumes that the town wants box stores and manufacturing in here, doesn't it?
That's what I stated, that retail box stores or manufacturing facilities would, which by nature would be the type of development that the town, from my understanding of what the town plan says for this area, that's what they're encouraging.
And where in the New Haven town plan does it say that they are encouraging box stores and manufacturing here?
Without going and trying to reference the town plan, I couldn't tell you right off the top of my head.
And the town plan, in fact, states it does not want strip development, does not?
I don't know that right off the top of my head. The town plan, I don't know.
And the town actually has a bulk coverage limitation of 25% per lot in this zone, doesn't it?
I don't know the lot coverage ratio for this area.
You reviewed the town's, have you read the town plan?
I have read the town plan, but I haven't memorized those details to be able to quote off the top of my head.
Give me a minute. I only have about 300 copies of the town plan on hand. I need to,
I have excerpts, if you want to identify a page number, I could pull it out.
Smart. So Thomas, I'm showing you, it's been marked as Exhibit NHDT2, New Haven Town Plan.
I have a copy for him.
Oh, beautiful. I'm sure you do. Thank you. And I'd like to, direct your attention, to the preamble on page 1. I'd like to direct your attention to the last sentence of the first paragraph. You could read that over, please.
Last sentence, first paragraph?
Yes.
New Haven's past has been strongly linked to agriculture for over 200 years. And there is a fervent desire to continue the scenic landscape created by this strong agricultural and rural heritage.
Does that reflect encouraging box stores and manufacturing, Steve?
Objection, that's argumentative. This town plan is 33 pages long to just, I think for the benefit of the hearing officer, to take one sentence out of the preamble and ask a witness how that effectuates a 33-page document would lead to a misleading answer.
I think your objection goes to the weight. However, I will say that the town plan has given extensive, the town of New Haven has given extensive comments regarding what they believe their town plan stands for, and the plan is going to be moved into evidence. So my understanding of Mr. Thomas's testimony is that he's not entirely familiar with the details of a lot of parts of the town plan at least as he's sitting here today. So, as from a time perspective, asking a lot of questions about specific provisions of the town plan may not be the best use of our time. So I'm gonna let you go forward with what you're doing. But
Well, let me just ask this. Can you point to me where that in that town plan it says the town wants box stores and manufacturing in this district?
I cannot.
May I object here because she's mischaracterizing, Mr. Thomas's testimony was characterizing the testimony of the town, which the testimony of the town is arguing that they want in this area commercial facilities that have jobs and can take advantage of Route 7. So his testimony is referring to the testimony filed by the town. And this mischaracterization, I think is inappropriate and misleading, and I object to the line of questioning. If you'd like to ask Mr. Thomas what he thought the town witnesses said in their testimony, that's appropriate, but he was commenting on their testimony. What he believed the town wanted there based on the town's arguments in this case.
I believe I already asked him what he understood that was, and he said he understood that the town wanted box stores and commercial development in this location.
Could I provide one thing?
is there a question for the witness right now? So,
No, there was no objection.
do you have any further questions, Attorney Hill?
On this line of questioning?
Yeah.
No, I have more questions.
Then I think we can just end it there and we'll move on.
At page 5 of your testimony, Mr. Thomas, you point to the 2008 subdivision of 66 acres to the south of this parcel. Tell me, as a commercial developer, what was the economy like in 2000?
I'm sorry, did you say page 8?
Page 5.
Page 5. Page 5, sorry. And where are you? Are you referring to page 5, lines 4 through 7?
Correct.
Sorry, did you repeat the question that she asked? I'm sorry.
Okay, at page 5 of your testimony, Mr. Thomas, you pointed the 2008 subdivision of 66 acres to the south of this parcel. Tell me, as a commercial developer, what was the economy like in 2008?
The economy in 2008 was a difficult environment for primarily residential construction. There were still other markets that were still strong, but residential markets were difficult.
And for new commercial development, what was the market like?
New commercial development was, especially in Vermont, not as impacted as the rest of the nation. I wouldn't say it was good or bad. Commercial development in Vermont is relatively difficult at all times. I wouldn't say there's any time that's been much better or worse. Residential was the primary market in Vermont that was impacted in that time.
The Act 250 permit that you have referenced and attached to your testimony, in fact, limits the development on that 66-acre parcel to only 19 acres, does it?
I'm not aware of the amount of the parcel that's being limited. It's quite commonplace for our larger parcel to identify a specific area to be considered for development, construction, and improvements, and make reservations on larger segments of the parcel to be preserved for non-development or other uses or natural resource easements, restrictive covenants.
And so that Act 250 permit for that parcel, 66 acre to the parcel apart to the south of this site, has restrictions such as you just talked about, doesn't it? It has restrictions regarding primary soils, mitigation, aesthetics, setbacks, and so on, doesn't it?
The objection that is a very compound sense. If you want to walk him through each of those questions, but I will say that the document is in the record, and I think it's inefficient to ask questions about what a document already says in Exhibit SSE 18.3.
Perhaps you can rephrase the question.
The Act 250 permit for the 66-acre parcel southerly of the subject parcel, in fact, places significant limitations on development on that 66-acre parcel, doesn't it?
I think the limitations are commonplace for a commercial development of 6 commercial lots with substantial footprint, substantial parking, substantial triptych generation. That would all be very standard for anything of that size. The necessary means to get approvals on a project like that is some things need to be compromised. They're identifying areas for intensive use and they're reserving areas for no use. That's very common.
And in your role as project manager on this project, you reviewed the Act 250 permit for the subject parcel, didn't you?
I'm aware of the Act 250 permit that exists on the underlying parcel. I'm not aware of all of the history that might go along with that parcel. I'm not the landowner and haven't, there's been extensive years worth of development there, but I'm not aware of all the details of everything.
And yet you reviewed and supplied the Act 250 permit for the parcel adjacent to this one.
The purpose of that was to identify literally development of the region and comment on the fact that my project potentially would be taking away available real estate within the town of New Haven's commercial zoning district and not allow other potential uses to come in on the parcel for where the project is located. I used the southern project with approved 6 commercial lots that have been there for greater than since 2008, so 6 to 7 years, where no development and no land transfer has been done, nobody's come in and purchased any of those lots, no infrastructure has been put in, that there is not the economic demand in the area for the type of projects that the town of New Haven is trying to encourage for that area. So when we comment on the order of the region, I don't believe my project is limiting a use that the town would incur for that parcel. I think I also reference a neighboring parcel directly to the west. It's shown on the site plan as the parcel which we've had significant discussions where the transformer pad is located. That parcel also has some level of commercial development approvals on it that was done as part of the greater project from New Haven, or from Mr. Norris with the state police barracks. It was a multi-lot subdivision. That parcel is also sitting undeveloped. The intent of the Act 250 permit that was submitted was to reference neighboring parcels, what their approvals are, and what their current status of development is in context of orderly development of the region.
So you did in fact review the Act 250 permit for this parcel, for the subject parcel, did you know?
I object. She's asked this question now 3 times and the witness has answered. He's generally aware of it. He has not reviewed it in detail and he's not the landowner. That's asked and answered.
Mr. Thomas, is there in fact a commercial septic system on the parcel on which you are proposing this?
Yes, there is, to the north of the project site, outside of the areas where I have site control.
And that is the subject of a wastewater permit, is it not?
I would expect if it's operating, it would be, yeah.
And have you reviewed that wastewater permit?
I briefly looked at it.
I'm showing you item marked as Towns Cross 2.
A&R was a party to this case. They reviewed the materials. They confirmed they had no issues with the number of conditions, and the board concluded in its September 2015 procedural order that we would not have a hearing on natural resources issues. Waste disposal typically falls under that.
Mr. Thomas submitted an Act 250 permit for the parcel south of this project area as evidence of relating to the orderly development of the region. And so it would proffer that the Act 250 permit for the subject parcel is also relative to the orderly development of the region. And that in fact, the Act 250 permit, which was approved by the town and related to the town's subdivision of the parcel, set out orderly development for the mother parcel and all the contained parcels here that is consistent with the town plan, and that in fact this parcel has commercial development on it already consistent with the town plan. And so that the Act 250 permit or permit packet for this parcel in fact reflects orderly development as envisioned by the town plan for this set of parcels, and it does not include this project.
Isn't this line of question with the wastewater permit?
Yes, which is part of the Act.
Which is part of it.
Yes.
And how does the wastewater aspect of this tie into that?
The wastewater permit requires that the remainder of this subject parcel shall remain undeveloped, and that the parcel on which the solar arrays are to be placed is to remain undeveloped, and that there are to be deeded easements for that parcel to the other subject parcels. So the wastewater permit requires that this parcel remain undeveloped
And
in favor of the three frontage parcels. And it requires that it remain undeveloped, and the Act 250 permit says it shall remain in agriculture in favor of the three frontage parcels, which are the commercial parcels with frontage to be developed.
And I obviously object to the characterization of that. A&R reviewed the file. They are very familiar with that permit, and they have no objections to the solar project being constructed.
I guess I would differentiate though between the, maybe the technical function of the wastewater system, which is what A&R cares about, and I guess I get your point that to the extent this wastewater permit implied some sort of scheme of development, I'd like to hear about it. So.
Can we have a moment to review it, because we have not been given a copy of what she's referring to?
Yes, let's do that, and then to the extent you have other cross exhibits, please
Thank you.
share them with Ms. Wilczek.
I have read it, but from a very different angle. That is the other person. So, this is the project, this is the 2-acre subdivision that was referenced.
certainly,
I'm sorry.
I'm sorry.
I'm sorry. All right, thank you.
So we have reviewed this in part. It appears to be over 100 pages, and so the witness can answer whatever he can.
Whatever you have knowledge on.
Yes.
Let's see what, if it looks like this is not a fruitful inquiry, then we'll cut it off, but let's see how it goes.
So, Mr. Thomas, referencing the item which I have marked with a sticky there as the wastewater permit, do you, as a commercial developer, recognize that to be a Vermont wastewater permit?
Yes, I do.
Okay, and on the following page, which I have marked with a post-it, it says shall remain undeveloped. May I draw your attention to point 1.5, the first paragraph? And is that in fact a condition of this wastewater permit?
Yes, I believe that is a condition.
And does it in fact say that this parcel consisting of 8.65 acres shall remain undeveloped?
That's what it says.
And turning to the page which is marked with a post-it that says lot number 1, agricultural and septic. Do you recognize that document which starts on the prior page to be a Schedule F filing to an Act 250 application?
Yes.
And so turning to the page which I had marked at lot number 1, ag and septic. May I draw your attention to a paragraph in the middle of the page which says lot 1?
Okay.
And is that, do you understand that to be a condition of the Act 250 permit?
I do have to object. This is really asking a witness, is this a condition of a permit? This is part of the schedule.
Are you
I mean, I just don't think we're giving good information to the public service board. And I also need to add that she did ask him questions, technical questions about a wastewater permit. The Agency of Natural Resources reviewed this case and it determined outside of this docket that solar can be developed in lots subject to wastewater permits. It happens all the time, and that's something that they don't even put in their comment letters to the board because they see it as a completely separate permit. So I just want to make that very clear, because the way the questioning was done, it's misleading in that she is asking him about a technical permit without any opportunity for context. So I wanted to provide the context of what happens in many solar projects where there's an existing wastewater permit. The solar project can be built, and the agency
I
is fine.
have one question for Ms.
Yes.
Are you planning on offering this into evidence?
Yes.
Does the applicant object to this document being put into evidence?
Yes. And I also
What's
add,
the basis?
I add that Act 250 permits have no applicability two parcels covered under section 248. The environmental court concluded that in Inri Cleve Mountain about 5-6 years ago, it was a litigated case involving the question of whether a generation company that gets a permit from the Public Service Board needs to pay any attention to underlying Act 250 permits, and the answer was no. So to be admitting Act 250 permits and expecting a generation developer to know every permit and condition would go against, I think, the environmental court's decision and that precedent.
Is the wastewater permit separate from the Act 250 permit? I mean, I know it's included as a condition of the Act 250 permit is compliance with the wastewater permit, but is it not a separate permit, separate statutory authority for regulating the wastewater systems?
Well, I would argue that the board in this docket, well, two things. To answer your question, the way she's presenting it, it's all as one. She's not proposing to enter into that separately. And even if she did move to enter in that permit separately, the board has concluded that the Agency of Natural Resources, charged with reviewing the environmental criteria, has already submitted its comment letter, and we were not noticed that waste disposal would have been an issue, or septic. If we were, we could have had A&R file a simple letter that says they know about this, and it's...
In making its decision about orderly development. I'll also note that it's a standard permit condition for CPGs that they comply with all applicable permits. So I think that's where this really comes in, is that, you know, the board requires development generally to comply with applicable permits, and if this is an applicable permit, then I'd like to hear argument about how this does or does not comply with it. So.
But I would like to, because I don't want to get caught in a situation where if the hearing officer does admit this, and then the town argues it didn't have an opportunity to cross-examine, we have to come back for a hearing. So to the extent that the witness can't answer questions, I think we would proceed on
Do you have any remaining questions about this document for the
Yes,
witness?
I do.
All right, I'll allow this to keep going, but what I'm hearing the witness doing here is reading sections of this to you, and that's not entirely helpful, especially if it does turn out that this is relevant, then it will be admitted and we'll have that information in the record. So with that in mind, I'll let you ask a few more questions and we'll see.
Okay, just to proper again, this is not offered for the purpose of Act 250 compliance, but rather relative to orderly development. Would be the town's position that the development scheme for this parcel and for this subdivision, as reflected in the Act 250 permit, which is also reflective of the town's subdivision, is in fact consistent with orderly development, and that excludes this project. And therefore this project interferes with orderly development because it is contrary to the land use scheme imposed on this parcel.
Assuming arguendo that argument is accepted, wouldn't then it just be sufficient to have the maps and the conditions in the record? And I'm trying to get at what I'm gonna let you keep asking questions. I just want to see what the purpose of those questions are.
This is the entirety of the Act 250 permit, which is also a public document in terms of its admissibility. So I proffered the entirety of the packet so that it would not be an incomplete record. Is how it's public. Where were we?
I don't know.
Hi, Mr. Thomas. How are you?
I think to make things easier, I'm going to withdraw my objection to the admissibility of this packet, and we can argue the relevancy both legally and factually in our briefs.
I appreciate your flexibility on this point. Are there any other objections then to the admission of this document? All right, New Haven Town Cross 2 is admitted.
So if we can.
I'm sorry, part of.
May I ask a procedural question? Is hearing scheduled to go to that time as well? I just see that it's a minute o'clock.
It's going to go as long as it takes.
Okay, thank you.
I neglected to provide it.
If you have a time constraint
I
for
have a
Mr.
site visit that I'm scheduled to go to this afternoon, so I would have to arrange for someone else to go for me.
Well, I'm sure we'll take a lunch break at some point and hopefully you can.
Sorry, Ms. Hill, is this for me or for the hearing
Yes, that was
officer?
for you. I think the hearing officer has one. So, if I understand it, then we're going to brief, both the legal and factual relevance of this, so then, I think that being the case, I don't think I need to continue the line of inquiry, because
Documents in.
Documents in and I'll argue.
So I do wanna make clear that the town does not need any more cross-examination on this document of the petitioner?
Correct. And that concludes my cross-examination of Mr. Wallace.
Any questions from the board? No. I have a few questions for Mr. Thomas. Several minutes ago, in response to a question from Attorney Hill about what land does the applicant control here, you said, correct me if I'm wrong, that the applicant has legal control of the southern hedgerow.
It does.
It does. My maps that I have, such as the site plan marked SSE GB2, shows that hedgerow is outside the fence.
That's correct.
So the area that is under the legal control of the applicant is greater than the area that's, what's inside the fence, it's more.
That's also correct.
What limits what area the applicant has legal control over?
There's no exhibit that we have today that's gonna show you that visually. That could be provided.
Is it a lease document?
If the lease document lease document exists, and the lease document doesn't define it like a deed. It's not describing the property with meets and bounds. It's not to define it that accurate. The lease document says that the project shall be located on this parcel in generally this area and have approximately this many acres. The lease document is also worthless without a CPG. So what we do is we will amend and provide the CPG and the components of the site plan that were developed that have the CPG that goes along with it as an amendment to our lease. That's typical. We currently have site control over, to describe it, using the existing gravel access drive as the northern boundary, the radio transmission tower as the northeastern boundary, everything south of there. We would then have a eastern border of the mature forested woodlands that are shown, all the way to the parcel's southern boundary line. And then that would be bordered on the parcel's western boundary, as you see on the site plan, up and back to the existing gravel access drive. That's the best description I could give you over what the leased area is.
Okay. Does the leased area include any of the two parcels that are occupied by the state police barracks?
The leased area?
Yes.
No.
So I'm again looking at exhibit SSE GB2. It shows a line of cedar plantings that would be located on the what I'm going to call the property of the Vermont State Police. Is that correct?
That's correct. That's how it's shown.
Does the applicant have permission from the state of Vermont to put those?
I don't specifically remember how we how we maintain site control on the state police barracks for the landscape mitigation plantings. I do recall, because it was done in a separate document, specifically how site control was for the authorization to put improvements on the parcel to the west was done for the underground electric line connecting to the Padmount transformer. That was a separate easement, and I specifically recall that easement, and that referenced landscape mitigation plans. I don't recall today exactly the document that was used on the state police barracks property side.
I'd like to make an information request, to the extent there is a document that discusses permission from the state of Vermont for those plantings, to be filed with the board and the parties.
May I ask one?
May I finish?
Oh, I'm sorry, go ahead.
Finish, and then you can
Of course.
do some redirect. If your follow-up question, Attorney Hill, is related to this this issue, then you should do it now, because I'm going to go on to the new topic. So.
It's related to that westerly parcel.
Okay.
The westerly parcel that borders Route 7.
Which one?
The westerly parcel on which you have the pad mount transformer.
Okay.
Did you notify, or what are the abutters to that parcel? Did you notify the abutters to that parcel?
Objection, that this has nothing to do with the section 248 criteria. I filed March 26th, almost 9 months ago, the list of the abutters that we notified, and that's in the record, and you can review that.
This is a legal argument. If you believe the notice isn't sufficient, then you should make that argument in your brief.
Okay, and I shall.
All right. The other question I have for you, Mr. Thomas, is about the Section 219A group system information. When Mr. Beldach's testimony was pre-filed, it indicated one meter to be included in the group that I guess was under the control of the applicant. Has the applicant identified any other meters that are going to be, that will be part of the group at this time?
Not that I'm aware of.
Would the applicant be opposed to providing a list of the meters to be involved in the group prior to commencing construction?
Just give me one quick. So is it a meter that's different than what was submitted in the pre-filed testimony?
The pre-filed testimony identifies basically two meters, saying one, the production meter that's going to be assigned a number at the front, and then it identified a number that was under the control of Mr. Beldach, I believe. I guess my question is, do you think there are going to be more meters added to this group in the future?
I don't know. As of right now, we don't expect that, no.
You don't, Mr. Beldach's other meter is anticipated to take all the power from this project?
Yes.
Okay. Then,
I could expand on that.
Yes,
but
please.
I guess maybe,
Yeah.
I mean, you got a question, so I'll try to. So, Mr. Beldach developed, owned, operated, and managed multiple senior living facilities. Those senior living facilities were sold in 2014, and as a contract, or as part of the contracts of that purchase and sale transaction, there is group net metering agreements that are associated with those existing facilities, and that group net metering agreement is what is allowing us to have a potential group net metering solar development project that would be associated with the meter of the prior senior living facility. That's the history.
so the meter, the consumption meter that was identified in the applicant's application is a consumption meter at one of these senior living facilities.
That one is,
That
yeah.
has enough load to take. Okay.
Yeah,
Thank you.
and there was three facilities that are relatively large senior living residential projects. All three of those facilities had the same contractual obligation that was embedded in the purchase.
Thank you. I have no further questions. Any redirect?
Okay,
That's okay, that's fine.
let's see. No, I have no redirect.
Thank you, Mr. Thomas.
Thank you.
List.
Brian Browning is the last witness we have for these criteria.
Excellent.
Brian, do you want to maybe
Want me to
sit
slide
there
up?
for a minute?
Yep.
Let me just- Here's a extra packet. And we provided the fast track study on August 13th, and I was gonna mark that SSE BB3, I'm sorry. So I've got that already marked. Okay, did you wanna swear him in?
Swear, not swear. Yes, I will remember to swear, Mr. Browning. Good morning. Would you please state your name?
Brian Browning.
Do you swear or affirm that the testimony you're about to give is true and accurate to the best of your knowledge?
I do.
Good morning.
Good morning.
I'm going to hand you your pre-file testimony dated March 26, 2015. Did you prepare that, or was it prepared under your direction?
Yes.
Is it a true and accurate copy?
Yes.
I'd like to move the admission of Brian Browning's pre-file testimony as if it was orally provided.
Any objection?
No.
It's admitted.
Take that back, please. Thank you. I'm going to hand you your exhibits, SSE BB1, which is your resume, SSE BB2, which is your one-line diagram, and for efficiency purposes, SSE BB3, which is the fast track study that we submitted on August 13th, 2015. Are those true and accurate copies?
Yes.
I'd like to move the admission of Brian Browning's exhibits 1 through 3 into the record.
Any objection? No. They're admitted.
Let me steal my packet back from you for
course.
a minute, because there's one thing in there that. Oh no, let me take that. I need to get his supplemental testimony. I'm going to hand you your supplemental testimony dated August 22nd, 2015. Is that a true and accurate copy?
Yes.
Did you prepare, or was it prepared under your direction?
Yes.
I'd like to move the pre-file testimony of Brian Browning into the record dated April 22nd, 2015.
I don't actually have that in my files. I'll look to take a look at it for you.
Oh yeah, sure. This is my only Yeah, okay, oh, this has to do with sound, it was a clarification on the sound
Oh,
levels.
okay. Okay, no objection.
Submitted?
And that's my only copy right now, so can I just hold on to that until we're done?
I don't think I might need a copy
I don't
because
think-
the sound is not gonna.
Yeah, right, I'm just gonna give it to you, I don't think I need it. Thank you. The witness is available for cross-examination.
Thank you. Mr. Browning, I was hoping that you could describe for me, in your answer 7, which is on page 4, lines 22 and 23 of your original pre-filed testimony, you note that GMP installed the underground facilities. Can you please describe for me those underground facilities?
So that would include the primary or the medium voltage line from a pole located at the road to the pad mount transformer and the pad mount transformer. Well,
And,
Oh, I'm sorry, I forgot to raise an issue that I wanted to raise before Brian was crossed.
Is this the objection?
Yes,
All right.
I meant to do it earlier.
Can we just wait until she finishes this question?
Yes.
I know
Yes.
you have an objection, and we'll listen to it in a second, but I don't want to interrupt.
Sorry. And it really goes to whether she can even cross Brian Browning
Okay,
or GP.
then we might as well get it
Sorry.
out, but I'm just gonna say I doubt I'm gonna rule on it today, but.
No, I know, and I do want to put it on the record
Okay.
that the town of New Haven did not identify in its motion to intervene over 9 months ago that it wanted standing on system stability and reliability. And as the board's recent order explained, even though the town has statutory status, it still needs to identify the issues that it wants standing on. And it did not identify system stability and reliability as an issue. So when when the board wanted information from Green Mountain Power on this issue, the town still did not request standing on system stability and reliability. So I am objecting to the admission of any testimony from Mr. Amalang. I apologize,
That's correct.
Amalang. Because the town did not identify system stability and reliability in its motion to intervene, and any cross-examination by the town on GMP or Brian Browning, because it has no standing on this issue. The town's represented by council, and council did not did not mention system stability and reliability when it moved to intervene, and that was a lengthy motion to intervene, and the board's recent order says the town has standing on those interests in its motion to intervene that it identified, and it did not identify system stability and reliability. I realize that you probably won't rule on that today, but I would like it noted because I am going to have that same objection for the admission of Mr. Emelang's pre-filed testimony. The second set, the first set addressed issues that are outside the scope of the docket anyway.
And I'm going to, I'm trying to cross the idea that pre-filed testimony needs to be objected to in writing within 30 days that it was filed, and I don't have the date that Mr. Amelong's pre-filed testimony was filed with us, but need to look at that. And then also, though I am aware that the idea of standing is something that never goes away. So I'm not going to rule on this right now. I'd like this to be something that you can address in your brief, and the admissibility of all the town's.
I'm not objecting to his testimony. I'm asking the board to enforce its own order.
So it's this is this is just you're saying that the town does not have standing on this
Right.
issue. Okay, well then that will be the resolution to that issue will be addressed in writing
Okay.
in order to follow. I also note that the applicant still has a pending motion for reconsideration in front of the board regarding its decision to expand the scope of this proceeding. So all of the discussion we have today about system stability and reliability is contingent upon the resolution of that pending motion and also the objection regarding standing. However, I'll again say it would be helpful to have some written, the objection written down for the board's consideration, because that's standing's a complicated issue. So.
Mindful of your ruling that this is a matter for briefing, I would just note that the issue of stability relative to this project arose later with the production of the fast track analysis, and that the board did grant, the reason that we're here on a system stability hearing is by granting of the town's motion.
Let's save the argument on this this topic for the written briefs. Thank you, though.
Thank you. Hi, Mr. Browning.
Hello.
Haven't forgotten about you.
Yeah.
We keep abandoning our witnesses here, I apologize. So I think we were talking about underground facilities.
Yep.
And I was hoping that you could show me, and perhaps, what I would like you to do is are you aware of the location of those underground facilities?
I am vaguely aware, just from a site visit that I did, but I don't have it documented on a drawing.
Okay. So what I realize this is slightly out of order, but I was going to ask you to draw where that location is. Would you be able to do that or no?
No,
Okay.
unfortunately not.
All right.
Yeah.
Then I have no further questions for Mr. Brown.
Does the department have any questions for Mr. Brown?
I have one clarification question, which you may or may not be able to answer today, and it does relate to the underground lines. Just try to get clarification on whether GMP will own the underground lines or the project will own the underground lines. And this is with a view to understanding the dig safe requirements.
Right. So my understanding is that GMP owns the medium voltage from the road to the pad mount transformer. So they would then be responsible for marking those. The project would own the underground lines from the transformer to the project site, and they would then be responsible for either coordinating that with GMP or hiring their own services to mark those.
Thank you.
I just have one question for Mr. Browning. Based on the fast track results received from GMP, and then also with a line towards Mr. Fisk's testimony, are there any additional facilities that the applicant will either have to construct or pay for the construction of to interconnect to this facility?
My understanding is that at this point there are no additional facilities required. The transformer has the capacity to accept the expansion of the project.
And no line protection anywhere else on the distribution circuit?
Not that I'm aware of.
All right. Any redirect? All right. Thank you, Mr. Browning.
Okay. You're welcome.
Do you just have the record for 1 minute, because I think I just want to.
All right, let's take a 5-minute break
Yeah,
while we switch gears here and go to GMP next. To introduce their witnesses.
Thank you. GMP will call John Fisk to testify, and before we do that, I just want to state on the record my objection, following up on the petitioner's objections earlier with respect to cross-examination by the town of the witness here. To the extent the hearing officer determines that the town doesn't have standing to participate in this proceeding on system stability and reliability, the cross-examination questions of the GMP witness would not be appropriate to make this an efficient use of everybody's time. We're going to proceed today, but my expectation is that the questioning would be limited to the board's order requiring GMP to participate on system stability and reliability with respect to this project, and that any cross would be limited to the scope of the pre-file testimony as well. So with that, I call John Fisk to testify.
Good morning, Mr. Fisk. Do you swear or affirm that the testimony you're about to give is true and accurate to the best of your knowledge?
Yes, I do.
Thank you, sir.
Mr. Fisk, can you state your name and spell your last name for the record?
My name is John Riley Fisk. My last name is spelled F-I-S-K-E.
I'm going to show you a copy of what's been labeled as pre-filed testimony of witness John Fisk. Can you take a look at that? Is that testimony that you caused to be pre-filed in this matter?
Yes.
And was that testimony prepared by you or under your direction and supervision?
Yes.
And are there corrections that you wish to make to that testimony?
Yes, there are.
And can you describe those corrections to us?
Okay, so on page 10 of 14, line item 9, where it says 80T, that should be 100T. On line item 10, it says 80T, that should be 100T. It says 80 amps, that should be 100 amps. Line 12, it says 330 amps, it should be 420 amps. On line 15, it says 280 amps. Or excuse me, it says 220 amps, it should be 280 amps. On page 11 of 14, line 4, it says 330 amps, it should be 420 amps. That concludes my corrections.
And can you describe for us the purpose of those changes?
So those changes are to accurately reflect what protective devices, either their settings are or what their size is in the field.
And were any of those changes you just identified in your testimony changes that you would consider material to the fast-tracked analysis that Green Mountain Power did with respect to the project under consideration?
No.
Do these changes that you identified in your testimony, do they affect Green Mountain Power's conclusion that the project under consideration can be interconnected without any adverse impact on system stability and reliability?
No.
As corrected, is this testimony true and accurate to the best of your knowledge?
Yes.
GMP moves for the incorporation of Mr. Fisk's testimony into the record.
May I request a clarification?
Yes.
Mr. Fisk, in regards to the change in your testimony, page 10, line 9 and 10, and so on, regarding the fuses, have the fuses been changed, or was your prior testimony in error?
Fuses have been changed in the field.
Fuses have been changed since your original testimony.
The fuses were actually installed prior to my original testimony.
So your original testimony was in error?
That's correct. That's what we're pointing out here, is that there was an error in the fuse size, and that's what we're correcting.
No objection with that clarification.
All right, then the testimony is admitted.
The witness is available for cross-examination.
I recognize that the GMP has expressed an objection about the participation of New Haven on this topic, and also I'm gathering the scope of the testimony that New Haven offered, some of which is maybe more general than the project specifically, but nonetheless, I'm going to ask this question, recognizing that there's pending objections, which is, Mr. Fisk, did you review Mr. Emelong's testimony?
Yes.
I'm not going to point you to the direct line. I'm just going to say that Mr. Emelong made a representation that there was an unwritten policy at GMP regarding the quickness of the review of this. Do you have a response?
So I would like to see that. So
Okay,
if
then
I
let's
could just
pull it
make
out so we
sure
can look at the
I'm
language
answering
specifically.
correctly.
have an extra copy.
I believe I have one right here. This is, I believe it's his pre-filed testimony dated November 9th.
I can provide my extra copy.
Okay.
Where was it in the original one? I'm sorry, hold on. No, I believe it's actually in the original.
It's in the original?
It's not?
It's in the original?
It's in the, well, I'm sorry that I did not copy it. Better, Mr. Amelung, if you remember where you said that.
Looking for it right now.
November 9th testimony, thank you. Starting at line 24, that's where the question. The question starts on line 24 and the answer from the witness is on line 28. And I'm just more interested to hear if the company has a response to the testimony on lines 28 through 30.
I'm sorry, what page was that? Sorry.
Page 16.
Let's have my copy then.
My response to that is that we're always looking for efficient ways of trying to move projects of all kinds through to be efficient, cost-effective, whether they're solar, reconstruction, what they are. But there is no unwritten policy that we will cut corners to put projects in service. I do not agree with that.
Any follow-up from the department or the town of New Haven?
No, I do have a step.
Oh.
I had just been thinking the department was going to go first.
Oh,
but I
I'm
guess
sorry.
we're not.
Okay, sorry to go out of turn, but you may.
Were you through?
I'm finished, so.
Okay. Mr. Fisk, I'd like to, if I may, ask you some questions about the location of this project on your circuit. So, I'd like to show you the, what I've marked as Town Cross number 5. Do you recognize that image?
I do.
And what is that?
That is the GMP solar map.
And where is the town of New Haven and this project located within that map?
So, may I go up to the exhibit
Please-
just to
please
make
do.
sure that we're looking at the right stuff there? My glasses on, see as I get closer.
I did bring extra reading glasses.
So, as I pointed at the map, it's in this area, the red area. It's very small scale and very hard to get very pinpointed, but it would be in the red area.
So it's within that westerly of the red zones. Is that correct?
I'll just encircle it with my fingers.
Sure, I can give you a
believe it
pen.
is. Right in that area. It's
Here, I'll
in
give
that
the
area.
witness a pen and you can indicate roughly on that map. Oh,
So, it's within that area, yes.
and, thank you. And can you tell me what distribution circuits are in that red zone?
May I object for a moment? I think we need a proffer from the town what this exhibit is. If it's an exhibit,
I
sorry.
apologize.
Sorry. If this is a map of GMP's system, after we filed our project, it does not represent the system as GMP analyzed it when it analyzed the interconnection application, and that's very important. And I think it would be misleading and inefficient to cross a witness on an exhibit that was produced after GMP reviewed this project. So I would like the town to explain the context of this exhibit, when it was produced, the date of this document.
So the project has not connected to the GMP system yet, has it?
Wait, sorry, so my question for the town is, when was this document produced by GMP?
Well, let's ask GMP, when was this?
It's your exhibit.
Okay, so it is a screenshot produced yesterday.
So I object to any questions on this document that is the system today.
May I ask a
Yes.
question, Mr. Fisk? Mr. Fisk, do you know if the GMP solar map, what, does that reflect built systems or systems within the interconnection queue? Do you know?
I admit that.
Okay.
That reflects systems that are constructed, also systems that are in the queue to be constructed.
Okay. Ms. Hill, based upon that representation, I'm not sure of the usefulness of this document because it reflects lots and lots of projects that may have applied after the project. It's not clear. GMP maintains an interconnection queue, and your place in that queue matters quite a bit for how GMP does its interconnection analysis. And so I'm just going to put out there that I think there is evidence in the record that there's quite a bit of solar proposed on the circuit that this project is proposed to be on, and if you'd like to talk about that, I think that's fine. But you haven't moved this, have you?
No.
Okay, so, but for the purposes of questioning the witnesses on this, I don't know what reliably we can answer about that. He can answer using this because we don't know what projects this reflects in the interconnection queue.
So, Mr. Fisk, this proposed project would be on distribution circuit WYG80, is that correct?
That is correct.
And on distribution circuit WYG80, there's actually more distributed generation in the queue than is presently connected, is that correct?
Correct.
Okay. And on, and that distribution circuit comes out of the Weybridge sub, is that correct?
That is correct.
And the Weybridge sub also serves distribution circuit WYG81, is that correct?
That is correct.
And on distribution circuit WYG81, there is also more distributed generation in the queue than there is presently connected, is that correct?
That is correct.
And those two circuits are actually interconnect at the substation, don't they?
So, I'm not sure I understand what you mean by interconnect.
They are, you have the ability to use those two circuits connected as a backup feeder, is that correct?
Yes.
And the Weybridge substation presently with the in-service and in-queue projects, including this one, is in a negative capacity state, isn't it?
I object to that question is confusing in the context of the question should all be whether what was the system like at the time GMP assessed the application, not what may have come after. So if you could reframe the question to be focusing on what information GMP had available at the time it reviewed this project, that's what's relevant, not what has happened after.
And yet, if we're looking at system reliability, and the project has not yet connected, isn't the question whether it can connect reliably without affecting system reliability?
Doesn't the company they have to review projects with reference to what's been approved prior to it. If someone comes along after them, after this project, and there are issues, isn't it that project's responsibility to deal with them, not this project's?
Well, then let me ask that question. Let me follow through and ask that question. It appears that today, the remaining capacity of the Waybridge substation is minus 1,900 kWs. So I'd like to inquire what it was at the time that this project was reviewed.
I'm going to object to the testimony we just heard. I don't think that, from Attorney Hill, I don't think that we've heard any testimony that accurately provides the information she just restated about negative capacity. That's not something that's in the record.
I still think, though, that the question she did pose, I think she tried to pose, which is what was the available capacity on the substation at the time the project applied?
Let's do
That, let's try that one.
What is the available capacity on the Waybridge substation at the time this project applied?
I'm not sure that I have that information in front of me, of what was on the substation at that particular time. So I can't tell you that right at the moment.
And your solar map ratings of the substation, information on the solar map regarding the substation includes everything that's in the queue up to the present day, is that correct?
Could you repeat that one more time? I missed it.
The information on your GMP solar map regarding substations includes everything both connected and on the queue up to the present time, is that correct?
That's correct.
So the information on the GMP map today regarding the Waybridge substation would include the queue that includes this project, is that correct?
Yes.
And so, again, today, it's at negative 1,900 capacity, is that correct?
Just to the form of the question, there's no foundation laid. If there's a document you want us to look at, let's see it and explain it, please.
I'll just also say that I don't quite understand what the relevance of what the condition of the substation is today. I mean, the reference points is when the interconnection request was filed with GMP, what was the analysis they did and what were the circumstances they considered at that time. There are a lot of projects, I'm sure, that may have applied after the fact, and the board and the utility and everyone else has to consider those at the time that those applications are considered. But I don't see the relevance of what the situation is with additional projects that have applied after this project.
So just to back up a second and clarify, you're saying you do not know, as you sit here, what the capacity of the Waybridge substation was at the time this project came?
Okay, so could you define what you mean by capacity?
Sure, you're familiar with the GMP solar map, correct?
Yes.
And so you're familiar with when you click on a substation to get information about it, that one of that point of information is the remaining capacity on the substation, is that correct?
Yes.
And so you tell me, what does GMP mean by the remaining capacity on the substation?
Okay, remaining capacity. I don't think I heard that in your question before. I thought I heard just capacity of the substation. The remaining capacity, according to your exhibits, and I have not pulled it up myself, just looking at your exhibits, is minus 1,900.
And what does that mean?
That means that the number of projects in service today and the number of projects in the queue, when you add up the total KW value, it exceeds the transformer rating, top rating, by 1,900.
Could you give the unit 1900?
Oh, I'm sorry, KW.
KW, thank you.
And that's in-service projects and projects that are approved and in the queue, correct?
So-
Objection.
So they're in-service projects, right? And there are projects that are in the queue.
Now, this particular project failed Vermont's fast track criteria 3, isn't that correct?
That is correct.
And that is the 15% load standard, is that correct?
That's correct.
And are you familiar with the FERC final rule on small generator interconnection agreements?
No.
Do you look to you look to the FERC rules for guidance on your industry standards for testing projects?
Objection. He just said he wasn't familiar with it.
Are you familiar with something called the minimum load test?
No. That would be more of explanation what you mean by that minimum load test.
Are you familiar with the fact that FERC and many other utilities require projects that failed the fast track to not exceed, to pass an additional screen which involves not exceeding 100% of the minimum load online?
Objection. This is beyond the scope of this proceeding.
Response?
Mr. Ryan, the witness testified that GMP proceeded with an abundance of caution in its analysis of this project. What I'd like to point out here is that the FERC standard, which is the federal rule, not directly applicable to states, but intended to stand as a model for the states, has in place a process for projects that fail this 15% fast track, and that is to go to a 100% minimum load test, and if they fail that, to go to system impact study. The witness said he's not familiar with that test. So this is relevant to his testimony that they proceeded in an abundance of caution when they did not apply the FERC standard, which is intended to be a model for the states.
Wait, the question that was objected to last was, can you repeat this last question about the FERC standard?
Question, are you familiar with the fact that FERC and many other utilities require projects that fail the fast track to pass an additional screen which involves not exceeding 100% of the minimum load online?
I guess just a yes or no is fine for this. Do you have a yes or no answer to that?
Yep, may I ask just one more time, I repeat it, I'm sorry, if you would please.
Are you familiar with the fact that FERC and many other utilities require projects that fail the fast track to pass an additional screen which involves not exceeding 100% of the minimum load online?
I am not familiar with that.
Mr. Fiskett, question 13, answer 13 of your testimony, it's on page 7, lines 7 through 9. You noted that GMP now knows that...
Let's get there, please. Sorry, I just can't go. Did you say page 13? What line?
7 through 9. stated that even exceeding 100% of minimum load threshold does not necessarily indicate islanding will occur. Can you explain to us here what you meant by 100% of minimum load threshold?
Still, we're on page 13?
We're confused.
Page 7,
Oh, page 7.
question 13, lines 7 through 9.
Okay. May I have the question again now that I
Yes, the question is, what did you mean by 100% of minimum load threshold?
So, the question is, the threshold, right? And so, we say that even if they exceed 100% of the minimum load, we are not saying that it indicates that islanding will occur, or that additional study or analysis of the load.
And what does 100% of minimum load mean? Please explain that.
Okay, so minimum load is a quantity that most utilities have not tracked historically, because we basically look at the maximum load to make sure that we don't overload systems. So minimum load is a number of the least amount of load that's going to be on the system. And 100% of minimum load is really 100% of minimum load.
And tell me, at this project, at the time that you analyzed it, how does it relate to the minimum load of this line?
Not sure I understand your question.
Would this project, SSE New Haven, have failed the 100% minimum load test?
So, again, I'm not sure I know what the minimum load test is. I'm confused as to what you're saying. Minimum load test?
The minimum load threshold. You said that even exceeding 100% minimum load threshold, did this project, at the time that you analyzed it, exceed 100% of the minimum load threshold?
So at the time of the study, the amount of generation to load was exceeded by 100%, correct?
By 100% or by more than that?
By more than that.
How much more?
It was 521% according to the fast track.
Is that to peak load or to minimum load?
So that ratio would have been based upon the peak demand at the substation.
So is that the same as the minimum load threshold?
No.
Okay. So my question to you is, at the time that you analyzed this project, did it exceed the minimum load threshold?
Yes.
By how much?
I don't have that number in front of me. Minimum load is not a number that we have tracked.
So you said that minimum load is not a number you track? And yet your testimony says that that GMP knows that even exceeding 100% of minimum load doesn't indicate islanding will occur. If you don't track minimum load, how do you know that even exceeding 100% of minimum load won't implicate islanding.
So, islanding, is a condition that the inverters, are designed to have compliancy with IEEE 1547 and protective devices to indicate and remove the system when an island occurs.
Correct, that's what islanding is. My question to you is, if you don't track minimum load, how do you know that exceeding 100% of minimum load doesn't necessarily indicate islanding?
Right, so criteria 3 indicates a 15%, which is based upon maximum load, and then they use a load to generation ratio of 50%. So half of, in a conservative estimate, or an estimate that's used by most utilities to determine what the minimum load is 30% of the peak load. So you take 30% of the peak load, and then you apply the rule of thumb that the load to generation ratio of less than 50% will guarantee that there's enough voltage and frequency deviations that generation will come offline. That gets you down to 15%. So that's how the criteria was there. It is basically a number, and what we're saying is that based on our experience is that when we have values that exceed that, we have experience and understand that the inverters have protections inside of them, both active and passive, that will cause the inverters to detect the island and remove itself from the system.
So let me go back through that, make sure I understood you. You said that the industry standard, if I understood it, correct me if I'm wrong, is that minimum load is presumed to be 30% of the peak load. Is that correct? Did I understand that correctly?
That's a rule of thumb that is used, yes.
That's a rule of thumb? And so when the fast track criteria here you said was 121% of peak load, you're saying that minimum load would have been 30% of the peak load, is that correct?
Correct.
So how far over the minimum load would this project have been?
Greater than 521, I don't have the numbers to do that calculation, or I don't have anything to calculate that with at this point in time.
So it would be well over 100% though, is that correct?
Objection. He's testified twice and he doesn't have the numbers and he can't calculate them.
So does GMP have any studies or data indicating that projects at 521% of peak load will assuredly not indicate islanding?
Objection.
What is the basis of the objection?
I'm not sure what the reference is, and I'd like clarification on what we're talking about, studies and data, I'm not sure what that is.
Did New Haven ask these questions in this discovery? GMP on this topic?
Perhaps I can rephrase the question a little simpler. Your testimony is that so GMP now knows that even exceeding 100% of minimum load threshold doesn't necessarily indicate islanding. My question is to you is, does GMP know, and if so, what is the basis of that knowledge, that exceeding 521% of peak load will not indicate islanding?
So, GMP's reason for stating that is that we know that the inverters have anti-islanding functions that will protective devices to remove it from service in an idling condition.
And the inverters you're referencing are the IEEE standard 1547 inverters, is that correct?
Correct.
And GMP has not, in fact, required the smart inverters with ride-through technology, is that correct?
Correct.
And are you aware that, are you aware of other locations in the country with solar saturation on similar levels to Addison County, Vermont, that have in fact required those smart inverters?
Objection.
The GMP council can proceed.
I object for two reasons. First of all, the question is outside of the scope of this proceeding, and secondly, I'm not aware that the record contains evidence of solar saturation in the area as the question assumed.
It seems to me that the line with the question you're pursuing here is though that somehow that the analysis that GMP has done in this case is not adequate. Is that what we're trying to get at
Correct.
here? Did New Haven present testimony showing other jurisdictions that do the kind of analysis that I assume you think should have been done?